Good evening, ladies and gentlemen. Wonder if we could start our event tonight. I'm Arthur Brooks, President of the American Enterprise Institute. It is my honor to welcome you to this 4th annual Walter Berns Constitution Day lecture. This is an event that we look forward to that has a special place in our heart, not mostly because it's an honor to our late and great colleague, Walter Berns. I am especially delighted to welcome Irene Berns here, Walter's widow, Elizabeth Fradkin, his daughter, and Dr. Hillel Fradkin, who joins us tonight, and all of you, many of you were friends of Walter. If you weren't friends with Walter as a person, you were certainly a fan of his work, as have been I for many years. I'd like to say a few words about Walter, and then I want to share a video with you about him that we'll be showing here for the first time tonight, but this will not be the last time that people see it. I think you'll be quite impressed with it. Many of you know Walter's background here at AEI. For those of you who don't, incredibly impressive. He began at AEI in 1978 after being as a resident scholar, after already having a very distinguished career as a professor at Louisiana State University, at Yale, Cornell, and the University of Toronto. And when he came to AEI, he also joined the faculty of Georgetown University shortly thereafter in 1979. He passed away very recently. This is the first Walter Berns lecture after his passing. He was 95 when he passed away. He worked here every day until he was 90. And when I mean he worked here every day, he was here every day working. He was a model of productivity for scholars. Really an awesome thing, an incredible thing for all of us, and we admired him for it. He was the author of many books while he was at AEI. He published For Capital Punishment in 1979. That was his first book as an author at AEI. In Defense of Liberal Democracy, Taking the Constitution Seriously, Democracy in the Constitution, Making Patriots in 2001, and also of considerable note was not a book, but a lecture, a Bradley lecture in 2009 right here in AEI, Lincoln at 200, Why We Still Read the 16th President. It's a highlight for many of us, and if you have not read it, I recommend it very, very highly to your interest. We're going to show you a video now that was just made to honor Walter, but it's also part of a series that we're hoping to do on AEI's greatest lights. This is certainly a category that Walter fits into centrally, and there are other AEI greats such as Irving Kristol, Robert Bork, Jeane Kirkpatrick, and the list goes on and on. This video has a larger purpose than just illustrating the careers of our greats. We want to do our part to keep alive and continue to stimulate interest in Walter's contributions to the study of American greatness. Its legacy is something that AEI is truly proud to be associated with. So with that, I would like to call our attention to the video about Walter Berns, and once again, thank you for joining us tonight.
Walter Berns was once a scholar and a patriot. And that, unfortunately, in the contemporary world and in contemporary America, is kind of rare.
Patriotism is not natural, but has to be taught or somehow acquired. And the question was then, and I suppose still is, how was this new patriotism to be taught or somehow acquired by later generations of citizens?
On the one hand, he loved the country, thought people had to be encouraged to love it for reasons that had been stated by Walter's great hero, Abraham Lincoln, especially in a free country. It can't be taken for granted that people will simply love the country and do the things that are needed to protect it.
This was not simply the rah-rah patriotism of a war hero, which he was.
Walter was a veteran of World War II. He had served from the absolute beginning in the Navy. He had seen action. I used to like to tell my children he had taken North Africa single-handedly, when they were still young enough to believe that. And so he had a very powerful sense of what the country had been through. And Walter in particular had a sort of odyssey after World War II. But eventually they pitched up in Taos, New Mexico, where a writer's artist colony had been founded.
Was going to be the, great American novelist, but then eventually he burned the manuscript. I just decided that wasn't him, and wound up going to the University of Chicago. And someone told him, you have to take a course with this fellow, Leo Strauss. And Walter said, I said, I'll do it next semester. Finally he did.
He was very greatly influenced by Leo Strauss, and Leo Strauss said, we should go back and read Aristotle. We should go back and read old books because we can still learn things from old books. And it's not enough to say, I don't completely agree. All right, you don't completely agree. What is it you think is right? And if you start by saying, well, no one is right, if there is no right, you're just going to go through life chortling and chuckling and being frivolous and silly, and that isn't the life Walter Berns was going to lead.
Walter believed that true patriotism for an American includes an appreciation of self-criticism.
We are not expected to love our country simply because it is our country. Love can be blind, and love of country, like love of wife or husband or lover, can be blind too. But ours is not supposed to be a blind patriotism.
But he always insisted that our criticism of the Constitution be fully informed, that criticism had to be based upon a full understanding. And it was that fuller understanding that he spent a good deal of his life in reviving.
Walter Berns was one of a very small group of scholars who made the founding relevant again and really fundamental to our understanding of ourselves. We take it for granted now that, well, of course, if you study America, you have to read the Federalist Papers and you have to think about the Constitution and the Constitutional Convention and John Marshall, not just the latest Supreme Court cases, and you have to read Lincoln. That was not the case when Walter Berns began writing on these topics in the 1950s and into the 1960s. And he and a small group of friends and colleagues of his really revived the study of the founders, showed why you couldn't understand America without understanding the founders.
I think part of what happened to Walter and to a lot of other people is that the left changed out from under them and came to really reject the vision of the Constitution. To be a partisan of the Constitution, which is, if Walter was any kind of partisan, I think that was his party, by late in his life meant that he was a conservative by default. But I don't think he was a conservative in the way that the conservative movement understands that term. I can see how Walter would be uncomfortable with the term, and a lot of people of his generation were. But the fact is, he and they transformed conservatism in a way that made it more like them. I think what today's young conservatives mean by thinking of Walter as a conservative is purely a compliment. It means that they see themselves shaped by his teachings.
Walter Berns was at AEI when I came here in 1986, and he was here for all of my tenure as president, up until his 90th birthday. He was in the office every day. Right up to the end, he was the complete intellectual and the archetype of what AEI has always tried to promote and insinuate into larger political debate.
When Lincoln was a young man, he gave a speech about the Founding Fathers in which he called them a forest of giant oaks. I thought Walter very much represented that image. These were people in the founding whom Lincoln felt had greater challenges than his own generation. Walter Berns was one of the giant oaks Lincoln spoke about, and he's left an extraordinary legacy for those of us who are still here at AEI. His scholarship and his great strengths as a colleague and friend to many here.
Well, good evening. My name's Gary Schmidt, and I'm the director of the program on American citizenship here at AEI, and your host this evening. Again, good evening, and welcome to those who have joined us here and those watching over the internet. Before I introduced our lecturer tonight, Philip Hamburger, just a couple of housekeeping notes. The first thing is we will end at 6 o'clock. They're going to need this room for a dinner after our event, so we'll hurry you off. But the good news is we will have a reception outside in the foyer with wine and cheese, so we can continue the conversation. So again, we'll end at 6, but again, we'll have a chance to continue our discussion out in the foyer. Second, I want to personally thank Sean Yetter, AEI's senior video producer, for the time and the effort and the care he put into producing that video. So is Sean here? But anyway, kudos to Sean. He put a lot of effort and heart into this effort. Now, it's a great pleasure that I introduce this year's Walter Berns Constitution Day lecturer, Philip Hamburger. Philip will be speaking on the topic of the Magna Carta, due process, and administrative power. Philip is the Maurice and Hilda Friedman Professor of Law at Columbia Law School. He is a leading scholar in constitutional law and constitutional history. Prior to Columbia, Philip's taught at the University of Chicago, Northwestern, George Washington, and the University of Virginia. If you look at Philip's syllabus online, you notice that he's written just a ton of important articles and books in constitutional law and history. I know Walter in particular was particularly taken with Philip's book in 2002, a volume whose title is Separation of Church and State, a treatise that thoroughly debunks the idea that separation of church and state was an underlying principle of the First Amendment. His most recent book is Administrative Law Unlawful, a volume that reviewers have described as immensely important, a cornucopia of fresh and significant insights. Nobody's ever referred to my book as a cornucopia. And a book not only for this season, but for many seasons to come. With that, please welcome Philip Hamburger to the stage.
Thank you very much. Well, what is Magna Carta? Does it still matter? And why? It cannot matter as a matter of law because it's no longer binding as law. In fact, now it's just an ancient document. It's written in language few can read, on parchments that are brittle and decaying, and even its historical significance is in doubt. If ever there were a dead constitution, this is it. So I'm glad it's my topic today. In fact, Magna Carta is commonly an object of disdain. Many scholars say that it did not protect the freedom of the people as a whole, but merely the privileges of those barons. They say that it addressed ancient specialized grievances, not enduring problems or principles. As put by the New York Times recently, Magna Carta was a result of an intra-elite struggle in which the nobles were chiefly concerned with their own privileges. In short, it is irrelevant. Now, I could just stop here and we could go get our drinks, but I guess not. It's not merely contemporaries who tell us this, and here it gets interesting. This is apparently an old theme. Those who have liked centralized, consolidated power have long treated Magna Carta as irrelevant. Medieval English kings, almost immediately after its adoption, regularly ignored Magna Carta, and they therefore were repeatedly asked to reissue it. In the 16th century, the High Commission, an early administrative agency, rejects arguments from Magna Carta, saying, and I quote them, that Magna Carta is antiquated and worn out of use. In the 17th century, Oliver Cromwell allegedly disparaged the document with his famous line, Magna Carta, Magna Farta, one of my favorites. And nowadays, of course, in many academic circles, it's considered naive to think of it as a constitutional document. One would sound unsophisticated and unknowing if one took it too seriously for constitutional purposes. And this, of course, brings us to Walter Berns. Writing of another constitutional document, one that is not quite yet dead, he urges us to take the Constitution seriously. Walter was a man of incorruptible integrity, a man not swayed by intellectual fashion and its rewards, a man devoted to intellectual inquiry and enduring truths, a man who understood the importance of our Constitution, a man who recognized the danger of attempts to disparage virtue, liberty, and law. And with his example in mind, I want to take Magna Carta seriously. I want to take it seriously as a constitutional document. Magna Carta, notwithstanding suggestions that it's irrelevant, old, elite, etc., Magna Carta still matters, not so much for what it says, but for what it reveals. What it reveals about an enduring danger and about the repeated constitutional responses. Magna Carta was the beginning of the long, long struggle in common law countries to rein in the threat from absolute power and substitute rule through and under law. And it thus allows us to trace the long ebb and flow of absolute power on the one hand and law on the other. Of particular interest, it opens up a window into what soon afterwards came to be known as the due process of law. Nowadays, due process of law is basically a procedural protection for what happens in court, not against what happens elsewhere, not for what happens in administrative agencies. Thus, in court, you are guaranteed the full due process of law. But in an administrative tribunal, you get only administrative process, a minimal process that is justified as, well, all the process that is due. Translation, not very much. Due process was once much more robust. It once set not only a standard for what happened in court, but it also barred binding administrative adjudications. And Magna Carta was the beginning of this robust response to administrative adjudication. Magna Carta thus opens up the real meaning of due process. It was the beginning of a long history in which it became apparent that binding administrative adjudication is a recurring danger and that the due process of law is a rejection of such adjudication. There are going to be 4 parts to this talk. First, Magna Carta. Second, the development of due process. Third, the destruction of due process. And then fourth, some counter-arguments. And I may drop that 4th part depending on how strongly the alcohol beckons afterwards. First, Magna Carta. Magna Carta is a charter, a grant, in which King John makes concessions to his barons. So how did he come to meet them at Runnymede? A beautiful name, quite poetic. How did he come to meet them there and in not such a poetic moment accede to such a document? It was a matter of brute force. King John came to power after a civil war, a contest for the throne, and already then he needed to reconcile many barons and churchmen. Why? Because he wanted to take their stuff. And so therefore, in 1200, at his coronation, he issues a coronation charter promising to limit taxes and the takings of church revenues. Their versions of taxing and taking were a little bit rougher than ours. It usually involved troops and spear points and swords. John soon distinguishes himself with a series of foreign failures. He's very apt to use force at home, but he's not so successful in force abroad. He fights a losing war with France, and by 1204, he had lost Normandy and Anjou. He quarrels with the Pope Innocent III, not a man to quarrel with on the whole, about the appointment of bishops, and especially the appointment of Archbishop Stephen Langton, to whom we will return. And this dispute lasts for years until in 1209, John is excommunicated for it. This doesn't help his reputation. Again, in 1214, he ventures off to France and is soundly defeated by the French king at Bouvines. John, therefore, was mocked as King Lackland, or better yet, Soft Sword. This man gets no respect, and probably for these purposes didn't deserve it. These dismal foreign failures lead him into domestic trouble, of course. For example, to support an army, John demands something called scutage, a feudal due, and he demands this in payment in lieu of military service from barons who don't fight. And of course, like so many English kings, he tries to expand on what feudal law allows him. In other words, he stretches his authority to take money, and he therefore revives the concerns that led to the coronation charter in the first place. Unfortunately for John, he took it further. He quarrels both with the barons and the church at the same time. His foreign policy and taxation annoys the barons, and his disputes with the Pope over the appointment of bishops annoys the church. And most prominent of his opponents at home was this man I mentioned earlier, Stephen Langton. Langton was, of course, a former academic, known to his students as Tongue of Thunder. And in 1207, he becomes the new Archbishop of Canterbury. Langton was elected and appointed over John's objections, and Langton and other bishops therefore provide the heft, the intellectual heft, for the coming rebellion. John thus makes the mistake of provoking both men of power and of intellect. But we know where that leads. Eventually, in 1215, it's a short civil war, just 1 month. In May 1215, there's a brief civil war. The key place, as always in England, to be controlled is London. Baron Robert Fitzwalter takes London, and after that, John has no options. He's just in a tough spot, and that tough spot's called Runnymede. June 10, 1215, at Runnymede alongside the Thames, he makes concessions in the Articles of the Barons, a sort of rough draft. And 5 days later, these are formalized in Magna Carta. By the way, quick quiz, why is it called Magna Carta? It's not that big. The answer is 2 years later, portions of it were sort of hefted off into something called the Charter of the Forest, And compared to the Charter of the Forest, Magna Carta looks pretty big, so it became Magna Carta. At any rate, what was the content of Magna Carta? Don't worry, I'm not going to read it to you, least of all in Latin. It contained 63 clauses, most of which concern matters that today will seem quite antiquated. Their meaning, indeed, remains obscure and debated, and there's little confidence about it except amongst a number of medievalists. Nonetheless, what I would argue, and I think is very true, it was broadly written and an ambitious document. It's often said, as I suggested earlier, that it merely protected the barons in their particular liberties, properties, not the broad populace in their general liberty. But this is simply wrong. It also protected some fairly broad liberties. And let me give you some examples. Clause 7, a widow after the death of her husband is immediately to have her marriage portion and her inheritance, thus protecting women's property rights. That's half the population. That's not bad. Now, of course, it's only part of half the population. Many don't have that much property, but you get the idea. It's a fairly broad protection. Clause 10, no one is to be distrained to do more service for a knight's fee or for any other free tenement than is due from it, thus protecting against a sort of taking under feudal law. Clause 20, a free man is not to be immersed for a small offense except in proportion to the nature of the offense. And a villain, in other words, an unfree man or serf, is to be immersed in the same manner, saving to him his growing crops. This is quite remarkable. Not just the barons, not just free men, nor even women, but serfs are protected by Magna Carta in this clause. Clause 40, to no one will we sell, nor to anyone will we deny or delay right or justice. That's pretty broad. All of these are general provisions which protected broad segments of the populace. One of the broadest clauses was Clause 39, and this talk will devote some time to it as we go along. Clause 39 says, no free man shall be imprisoned or dispossessed, except by the lawful judgment of his peers or by the law of the land. This laid down principles that were not yet tried by jury and were not yet due process of law, but they were the foundations of these rights. In a sense, these were the broad principles that become these rights. Before turning to due process, let's conclude our discussion of Magna Carta by considering its afterlife, which is as interesting as what led to it. Magna Carta was not the last word on its assurances, because in the Middle Ages, what we would consider constitutional documents were then just the personal assurances of the monarch. And of course, that can come and go, not merely with the king's death, but if he changes his mind. So successive kings, therefore, need to reissue Magna Carta to show their commitment to it. And incidentally, we have echoes of this still in our Constitution. Where? In the President's oath of office, when she swears to preserve, protect, and defend the Constitution of the United States. This is an echo of that personal commitment we want from our leaders. Already on John's death in 1216, his 9-year-old son, Henry III, reissues Magna Carta with some provisions omitted, but he does it to avoid further unrest. Again, he has to get that commitment out there early. And it's repeatedly reissued in 1217 already again, 1225 in exchange for grants of taxes. And the 1225 issuance becomes the basis of all the later reissuances, and these continue until 1300. So in fact, now there are many, many copies of Magna Carta scattered across England, because every time there's a reissuance, you have to send copies out. And they lie in these great halls and in these abbeys and cathedrals and in museums. Much later, in the 17th century, Parliament reasserts Magna Carta. Parliament recites portions of it in 1628 in the Petition of Right, and in 1641 when abolishing the Star Chamber. This is a 17th century abolition of administrative agencies, something devoutly to be wished, but it will take us a while to get there. But thereafter, Magna Carta becomes merely a matter of history. And therefore, let's stop talking about it and focus just on that one little portion of interest today, clause or section 39, and where it led to. So the second part of this talk concerns the development of the due process of law. My argument is that Clause 39 and later concepts of due process developed precisely to defeat prerogative, or what we call administrative adjudication, the binding adjudications that occur outside the courts of law. Thus, rather than merely a set of standards for the courts, something the courts look to figure out what they should do inside the courts, due process of law also, perhaps even more centrally, bars binding administrative adjudications. The origins of due process can be found in Clause 39 of Magna Carta. Remember, rather than use due process of law, it states, no free man shall be imprisoned or diseased except by lawful judgment of his peers by the law of the land. Now, the meaning of this is much disputed and has been for hundreds of years. For example, what was the lawful judgment of one's peers? Some say it refers to juries, but that's a little awkward because juries don't become really a regular part of English life till about a century later. So it'd be odd if that were just referring to juries. In fact, the trial by one's peers is a widely admired ideal, not only in England, but also on the continent. And tellingly, it's guaranteed here not just for barons, but all free men. So it doesn't narrowly refer to juries, but apparently refers to the underlying principle. The Pope, by the way, was a great advocate of trial by one's peers and urges it on John. This is a widely admired ideal. So why did Clause 39 emphasize these two principles, judgment by peers and the law of the land? And again, the key is it's designed to bar binding adjudication outside the courts. In other words, what we call administrative adjudication. How do we know this? Well, this isn't the place for digging into medieval documents, but two examples I think should suffice. And we have actually a remarkable amount of information leading up to the adoption of Magna Carta. So we know this stuff with great confidence. In letters patent, in other words, a grant, of May 10, 1215, John assures his baronial opponents that, and I quote, he will not arrest or seize them or their men, nor go against them by force of arms, except by the law of the land and by judgment of their peers in his court. What he would tend to do if he disapproved of what someone was doing was simply attack them, take their stuff, sometimes castles, sometimes agricultural property, or sometimes raise an army and defeat them. And it wasn't just barons. He'd go after people's retainers. The barons are not just trying to defend about themselves. Their power lies in their retainers and all the common folk under them. They need to protect them from people like John, and he knows that. He goes after them. Other evidence comes from the so-called Unknown Charter, so-called because it was not known until the late 19th century. The Unknown Charter, now of course it's very much known amongst people in the field, Unknown Charter really just records talking points. It's like the list of talking points when you go into a meeting. And this was for the negotiations for Magna Carta. And the very first clause of the Unknown Charter begins, King John grants that he's not to arrest a man without judgment. So what we're talking about here is the danger that the king, the executive, will go after folks without going to a court for a judgment. Article 39 takes aim thus at adjudications outside the courts. What civilian commentators like Baldus and Jason DeMeo, continental writers of the civilian tradition, called extralegal adjudication, what we call administrative adjudication. J.C. Holt, the leading historian of Magna Carta, writes that Clause 39 was aimed primarily against arbitrary disseisin at the will of the king, summary process, and arrest and imprisonment on administrative order. Or another historian, John W.L. Warren, not as good a historian, but still reasonably good, said, sorry, we make these sort of distinctions amongst our fellow scholars. Clause 39, he says, targets executive action against offenders. These are from the folks who specialize in 12th and 13th century history, and I think they're on point. Now, this is important. Magna Carta itself is just history, but administrative adjudication is now more common than it ever was before in the past. And this suggests that whether you call it prerogative or administrative, this sort of adjudication is a recurring danger. Something comes back again and again. Governments are never content to govern just through the law and the courts. They repeatedly seek other extra-legal modes of power, and just because we replaced a monarchy with a republic doesn't mean that the problem has gone away. Although Magna Carta's history, the central danger address is very much alive. How did Article 39 become the due process of law? How did it get rewritten? This happens through a series of 14th century statutes. And these statutes confirm, these due process statutes confirm, that due process was primarily decided as an obstacle to administrative adjudication. The statutes were prompted by the prerogative or administrative misconduct of Edward III. Edward III was not satisfied to hold his subjects to account in the courts. He liked to summarily just call them before his council for questioning and punishment. So in 1354, Parliament enacts the first due process statute. It echoes Magna Carta's Clause 39, and it says, no man of what estate or condition that he be, and notice that includes serfs, shall be put out of land or tenement, nor taken, nor imprisoned, nor disinherited, nor put to death, without being brought in to answer by due process of law, meaning the process of the courts of law. Of course, Edward was a king, and he didn't like living up to his statutes. And within a decade, he's doing it again. So next decade, what happens? Parliament in 1368 passes another due process statute. And this one's even more vigorous. The preamble recites his attempts to hold subjects to account before the King's Council, and he says that these are against the law. And the statute then provides that no man shall be put to answer without presentment before justices or matter of record or by due process and read original according to the ancient law of the land. And this is summarized in the manuscript Parliament roll. In the margins, someone has written, none shall be put to answer without due process of law, something that just summarizes the whole statute very nicely. Now, this is interesting. It makes clear that any attempt to bind subjects in the king's prerogative or administrative council, even merely to summon them in for answer questions, not punishing, just to ask questions and force them to come in, is unlawful. Due process barred any attempt at binding administrative adjudication. But it gets better than this. One of the most curious aspects about the 1368 due process statute is its final clause about the judges. It instructs the courts, if anything henceforth be done to the contrary, it shall be void in law and held for error. Now, this has long puzzled commentators for 100, 200 years. They've said, what's going on here? Maybe this is the invention of judicial review in the 14th century. This is nonsense. The judges regularly held unlawful royal grants and acts unlawful when they were unlawful. They therefore don't need a statute to tell them what to do. So why then this final clause? And I think the answer is judicial deference. The judges had previously deferred to the king, something they're not meant to do. The kings very often interfered with the courts, sometimes sat on the courts, sometimes sent them little messages, little notes telling them what memoranda, what to do. And to prevent any such deference in this instance, Parliament adds, if anything henceforth be done to the contrary, it should be held void in law and held for error. Now, what are the consequences for administrative adjudication? Well, we actually know, because we have fairly good court records from the era. And we know the answer from a 1368 case. A commission, an administrative commission established by Edward, seizes and imprisons a man and takes his goods. What happens? It comes before the judges, and the judges hold the commission void, saying, and we have their words from the yearbooks, it was against the law because it authorized the commissioners to take a man and his goods without indictment, suit of process, or suit of party or due process. In other words, adjudication outside the courts was contrary to due process. The judges held it unlawful without any deference. Times have changed. So this role of due process in precluding administrative adjudication remains familiar. It doesn't just disappear in the 14th century. It's the petition of right. Charles I comes to the throne in 1625 and soon is demanding money for bad foreign policy, of course, and not merely under law, but also on the basis of prerogative or administrative edicts. And to enforce his demands, of course, he penalizes non-compliant men in administrative proceedings outside the courts. Parliament responds in 1628 with the petition of right, which echoes Magna Carta and the due process statutes. It recites, no free man may be taken or imprisoned, but by the lawful judgment of his peers by the law of the land, and then quotes the 1368 statute, no man shall be taken or imprisoned without being brought to answer by due process. And this knowledge of this history, of course, remained with lawyers for a long time to come. So let's move from the 17th century to the 18th century. When the US Constitution, the Fifth Amendment, guarantees the due process of law, it continues in the tradition of Magna Carta, the due process statutes, and the petition of right. Although it sets standards for the courts, it more basically bars any binding adjudication outside the courts. How do we know this? Well, they knew the history, but there must be more. Well, consider the very words of the Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. If this merely limited what courts could do, it would have been stated in the active voice. No court shall deprive any person of life, liberty, or property without due process of law. But instead it was written in the passive voice, and it thereby limited all parts of government. And this, by the way, is true of much of the Bill of Rights, especially the procedural rights. Most of the Bill of Rights guarantees procedural rights. And most of these rights, including the Fifth Amendment, traditionally were barriers to adjudication outside the courts. The Bill of Rights, therefore, had to limit not just the courts, but all parts of government. And they therefore had to be put in the passive voice. Not only the particular words of the Fifth Amendment, but its location is also revealing. In that sense, the structure of the writing of the Bill of Rights matters. To bar administrative adjudication outside the courts, the Fifth Amendment could not simply modify Article 3 of the Constitution, for then it would limit only the courts. It therefore also had to limit the executive in Article 2 of the Constitution. How do you do this? The drafters of the Bill of Rights therefore changed how they wrote it. They initially thought, we're going to adopt amendments that alter the writing of particular articles of the Constitution. So any change about due process might have been in Article 3 on the courts. But ultimately, they changed this, and they adopt simply amendments at the end of the whole Constitution. And this matters because it allows the amendments to limit all parts of government, Congress and the executive, not just the courts. In the case of the Fifth Amendment at the end of the Constitution, it's clear that due process limits not just what happens in court, but also what happens in the EPA or the FDA. So in these ways, both the text and location of the Fifth Amendment and other procedural rights make clear that they limit all parts of government. That is, they limit not only courts, but also Congress and the executive, and they therefore bar administrative power. As you can tell, I'm arguing rather didactically here, but I think it's because there's a lot of evidence, and I want to share that evidence. The implications for due process were not a secret, moreover. They're recognized in the earliest academic commentary on the Federal Bill of Rights. Now, most people haven't read this commentary because it's in manuscript still, but it's easy enough to read. I can even send you a PDF of it if you want. St. George Tucker, a Virginia judge, teaches constitutional law beginning in 1791 at William and Mary. After quoting the Fifth Amendment's due process clause, he concludes, due process of law must then be had before a judicial court or a judicial magistrate. You can't get clearer than this. The Fifth Amendment bars the government from holding subjects to account outside courts and their processes. This was the breadth of the principle from its very beginnings. It was how the Fifth Amendment was drafted and understood in 1791. In short, we can see here a development of ideas about due process that runs directly from Magna Carta's Article 39 and 1215 to the 1368 Due Process Statute to the 1628 Petition of Right to the Fifth Amendment in 1791. Throughout this history, due process is a bar to administrative adjudication, to adjudication outside the courts. What you call prerogative administrative, it violates due process of law. So how did this all change? We now have administrative adjudication on a vast scale, and the Supreme Court tells us this does not violate the due process of law. How did the concept of due process come to permit what it once centrally forbade? So that brings us to the third part of this talk, the destruction of due process. This destruction of due process is an achievement, I suppose, of our times. It reflects our great accomplishments in administrative power. And it comes in these two layers, a practical evasion of due process and the evisceration of the very concept of due process. Let's begin with the practical evasion. The central threat to due process is administrative power, in particular administrative adjudication. It evades the courts, the judges, the juries, privilege against self-incrimination, and most other procedural rights. It can be summed up as the evasion of due process. And just to be clear, I don't want to overstate anything here. Just to be clear, when I criticize administrative adjudication, I mean binding or constraining adjudication outside the courts. The issuance of administrative edicts in particular cases that bind or constrain persons subject to the law of the United States. So in other words, my argument does not include the adjudication of benefits, such as Social Security, nor does it include any adjudication of the status or detention of enemy aliens or other aliens not in amity. Instead, the problem is binding or constraining adjudication that evades the due process of law and most other procedural rights. This is the most serious assault on the Bill of Rights in the nation's history. It practically eviscerates it. We have a few substantive rights, but all the procedural rights, which are most of it, are rendered of much diminished value. So what's the practical effect of this evasion of due process? The real result is what I would call ambidextrous enforcement. When due process was guaranteed, the government could constrain Americans only in particular cases through the courts and the judges. Now the government can choose to set up administrative adjudication, and thus has a choice. You can proceed through the courts in their due process, or through administrative adjudication in its, I call it, faux process. The SEC, the Securities Exchange Commission, is a timely illustration. It can refer cases to the Justice Department to prosecute defendants criminally, or it can proceed against them in-house through its administrative law judges. When the SEC does not expect to win in court with juries and due process, it simply proceeds with the ALJs, the administrative law judges, without juries and without due process. How convenient. Is this really the way they think? You bet. Last summer, the SEC's Director of Enforcement candidly explained that the SEC might pursue cases administratively when it did not expect to prevail before a jury. You can't get blunter than this. The problem, however, is much broader. Because it's not merely that an agency can choose enforcement in a court or out of court. Instead, the problem is all administrative adjudication. All of it is an evasion of due process. All of it occurs whenever Congress authorizes agencies to work through administrative adjudication. So whenever an agency engages in administrative adjudication, the government has chosen to evade the courts, judges, juries, and due process. And this evasion, whether chosen by the agency or by Congress, is a core element of the administrative state. The problem, in other words, is not agency discretion, but government evasion. It's not a particular agency's choice, but the Congress and the government as a whole has chosen to establish paths of enforcement outside the courts, and thereby evade much of the Bill of Rights. So much for the practical evasion, but it gets worse. It gets worse because the Supreme Court has eviscerated the very concept of due process. To accommodate administrative adjudication, the due process of law has been reconfigured as the process that is due. Probably one of the smarmiest phrases in our jurisprudence. Put simply, whereas due process once was the due process of law, meaning the process of courts of law, it now incorporates the evasion in its ambidextrous vision. It now means either the due process of the courts of law when the government chooses to proceed against you in a court, or merely administrative process when the government chooses to authorize administrative adjudication. Due process is therefore now bifurcated into the government's choice between judicial due process and administrative faux process. Whereas it once was a guarantee against the government, it now is merely an option for the government, an option it can choose or not as it wishes. Now, I don't know how much more time we have. Do we have time for another 5-10 minutes of this? Okay, we'll go on to the fourth part. And you don't worry, you won't miss your alcohol. Fourth, let's look at some counter-arguments. I just want to run through some of them because some of them seem almost plausible. Almost. One counter-argument is that administrative adjudication is actually, well, very fair. Administrative adjudication often comes with administrative law judges, the ALJs, most of whom are very conscientious and are protected in salary and tenure. It also comes with hearings and evidence and often a formal record. So in theory, it's not really so bad, in theory. In fact, this is just a whitewash. Consider the personnel, the judges. Many administrative adjudicators are not ALJs and therefore do not have any independence. Even ALJs, the administrative law judges, are not really independent. ALJs can be demoted or have their salaries docked if they reject administrative regulations as unconstitutional. They don't really look like judges then, do they? In a 1992 survey of ALJs, and by the way, there's remarkably little study of these folks and most adjudicators because guess what? HHS treats lots of academic speech as a health threat, and I'm not allowed to question them. I'll lose my job if I try. You thought McCarthyism was bad. A 1992 survey of ALJs reveals that 15% complained of threats to their independence. 15%. 8% said it was a frequent problem. Just recently, to take an example from the news, Lillian McEwen, a former SEC ALJ, protested against intimidation by the SEC. The SEC has investigated this and decided there really wasn't a problem, but Ms. McEwen clearly is a very different opinion. Moreover, even the decisions of ALJs are often subject to review or being finalized by heads of agencies. So it's not actually the ALJ who finally decides. The final decision or review will come often from the head of an agency who did not hear the case, or political appointees, and don't even have the pretense of independence. Now consider the process. Agencies rely on subpoenas for their discovery without usually allowing the same amount of discovery or any discovery for defendants. Moreover, there are no juries, even when the agency proceedings are criminal in nature. The burdens of proof and persuasion are often reversed, so the defendants have to prove their innocence. And this reversal of burdens, for example, is evident, for example, in most licensing proceedings or whenever an adjudicator takes official notice of facts, which is quite common. Rather than due process of law, this is at best a pale imitation of it. That's why I call it the faux process of administrative regulation. Another counter-argument is that we can always get due process later in judicial review. But this delayed due process argument is farcical. For one thing, due process, juries, and procedural rights are rights in the first instance, not merely on review. In fact, some of the earliest state cases from the 1780s repeatedly held that judicial review, even with a de novo hearing and jury rights in court afterwards, in point of review, does not cure administrative violation of jury rights in the first instance. From this point of view, administrative adjudication already violates procedural rights regardless of any review. The delayed due process justification, moreover, is also farcical because of the doctrine of exhaustion of administrative remedies. For practical purposes, this means the exhaustion of administrative defendants before they get to court. An agency, this is quite common, I get phone calls from people who have been essentially worn out by the agency in administrative hearings, and then they get to go to court when they're in bankruptcy or they left the country because they're utterly impoverished. There's nothing they can do. And legal services doesn't help them. So the agency will often deliberately actually use its administrative proceedings to exhaust defendants' finances, and then you take them to court. If you lose, or they'll take you to court. The delayed due process theory is especially farcical, of course, because even when you get to court, you actually don't get due process. When you get when you appeal an administrative decision to the courts, the judges defer to the government's administrative record. In other words, the government's version of the facts. So it's actually entirely prejudiced understanding of the facts. The judges defer to the government's interpretation of the law. In other words, they defer to the government's legal position. That's the so-called Chevron doctrine. Even when the judges hold an agency action unlawful, they often hesitate to hold it void, but instead remand it to the agency to change its action, something they'd never do for any other party. Even when the lower courts, the circuit court even, declares an agency position void, the Supreme Court will allow the agency to disregard the court decision, this being the Brand X doctrine. All of this is systematic judicial bias in favor of the government and other parties, and against other parties. Thus, even if later judicial review were a cure for the administrative denial of due process in the first instance, this judicial review of administrative hearings looks very different from other judicial review. In fact, it's systematically biased. Rather than delayed due process, it's a gross violation of due process itself. In this way, the whole administrative system really corrupts the judges. So this is my argument in an article called Chevron Bias. You can read it on SSRN. And I'm glad to say, perhaps on account of this article, the Supreme Court now recognizes there is a problem. It's revealed it in King versus Burwell and Michigan versus EPA, in which they relied on Chevron only to say no to an interpretation, not to say yes. I think this means they are beginning to get it, that this is not just a matter of allocation of powers amongst parts of government, but in fact the judges have been rendered biased by this doctrine that they've adopted. In sum, the administrative evasion of due process is not cured by later process. Instead, it reinforces the initial evasion. A few more quick counter-arguments. How much time do I have? No? Okay. I'll just keep on going. I'll just move past these. So I say there are other counter-arguments, and I'll get to them. Questions if you want. Let me just conclude. There's been nearly 1,000-year common law struggle for government under and through the law. Repeatedly, extralegal power, whether prerogative or administrative, has evaded passive law, thereby provoking constitutional responses. The constitutional barriers have included Magna Carta, the due process statutes, English constitutional developments of the 1620s, the 18th century American constitutions. But extralegal power has always returned. And the resulting ebb and flow of law, and in the ebb and flow of law, most procedural rights are now at an ebb tide. The current administrative evasions evade courts, judges, juries, in general terms, most of the due process of law, and they make a mockery of the Bill of Rights. In these circumstances, the US Constitution, sadly, has never been less relevant. And Magna Carta has never been more relevant. Our constitutional rights of due process and most procedural rights are increasingly looking as if they're lost in the midst of time, as much as the provisions of Magna Carta. And Magna Carta is therefore especially relevant because it's a reminder that extralegal power, including judicial power outside the courts, is an enduring danger. It's a danger that's over 1,000 years old, that is nearly 1,000 years old, a danger that constitutional documents repeatedly have interred, but that always comes back from the grave. In 1590, in protesting against the High Commission, one of those early administrative agencies, a prominent lawyer of the time, James Maurice, protested. He asked, "Where is now the Great Charter of England? Where is now the Due Process Statute?" And we might ask the same questions. Where is now the Constitution? Where is now the due process of law? Times have changed, but the danger endures. And this brings us back, finally, to Walter Berns. Walter recognized that underlying constitutional law are the failings of human nature, and he therefore understood the recurring character of the threats to law and liberty. Law changes, but we, sadly, remain all too much the same. And for this reason, and for many, many others, he will be sorely missed. Never in this nation's history has law been more at risk, and because of administrative power, most of the Bill of Rights, including due process, has become merely optional. More than ever, therefore, we need to follow Walter's example. We need to keep our eye on the Constitution and the enduring dangers to it. Thank you.
I apologize to Philip for sort of rushing him along, just for this squeeze for space at this point. But we do have time for a few questions, and if Philip would entertain a few, just please wait for the microphone and then identify yourself, and do make it short since we are squeezed for time. So, yeah. Thanks.
My name is Li Yang. I just wonder if there's no due process, or there were sort of equivalent to abuse, or in another part will become involved with fraud and crime. So would this statute of limitations apply to this type of situation?
Does the statute of limitations
In
apply?
other words, you always have right to pursue until the results in your favor.
Right. So it is true that one can keep on, certainly one can keep on pursuing one's complaints against the administrative system in the courts all the way up to the Supreme Court. Unfortunately, because of Supreme Court doctrines, one often loses because the courts are predisposed to the government's legal position and its account of the facts, which is not the ordinarily how we just, if you think about it, there are two issues in every court case, the facts and the law. And on both of these, you're apt to lose when you fight administrative power. So one can keep on, if I understand your question correctly, yes, one can continue to challenge these, at least within a statute of limitations, but it doesn't do one much good if the Supreme Court creates judicial biases. So one can get it to court.
Thank you. Yes, I was just wondering if you could give us a sense of what you see as the magnitude of the issue here. I imagine one of the counter-arguments would be that your standards would sort of have such a great impact on the way the government functions as to be impractical. And I was just wondering what you saw as sort of the general magnitude of it.
Right. So one of the standard arguments in favor of administrative power is the old argument from necessity, which has always been the argument for absolute power from the Middle Ages onwards. But necessity now cannot be simply declared by any of us, academics, or by a king. Necessity actually is an interesting question. That's something one could prove. And interestingly, notwithstanding all the claims of the necessity of administrative power, there's been no effort to prove its necessity. I think the burden of showing necessity is on those who want to deviate from the Constitution. So let them show the necessity. Now, I think it's perfectly reasonable to ask, is it nonetheless impracticable? So those of us on the other side perhaps should have something to say about it. Put briefly, I don't think it's as impracticable as one may suppose. Much of administrative adjudication is on benefits, and I'm not challenging any of that. In key areas, for example, the FDA licensing of drugs, there's actually a fairly limited number of drugs that come, like on average about 30 drugs come per year before the FDA. They can weigh in on this, and then Congress could vote on it if you want Congress to decide this. If you want to go to the courts, again, this is not an enormous number of cases. Now, that's not to say there isn't a risk here, but notice the question of whether or not you have to carry a jury in all these cases, or at least have a right to a jury in all these cases, must be combined with questions about what sort of law is applied. To the degree one has law that's relatively clear, that just allocates authority rather than trying to do complicated substantive justice, one actually could manage with juries quite reasonably. So it really depends on the nature of the law. And if you don't adjust the regulations, then yes, we might run into some difficulties. But I think that's a complicated problem. It's not one that's an either-or thing.
Thank you very much. My name is Ted Ellis, intern from the Heritage Foundation. Because the Magna Carta is the kind of ground, the focal point of this discussion, I was wondering if you could tell us more about the state of administrative law and ALJs in England.
Fortunately, I have not got enmeshed in their system of administrative law, which I imagine is even worse than ours. because the English have embraced it whole hog, as it were. They still actually have on the statute books Article 39, but it's more as sort of a memory. It's like a photograph of a long-deceased relative. It's not that you're actually living up to their Victorian standards of probity. And so it's more for decoration, and they know it. No, they have a massive administrative state, just as we do. My sense is, it's in years since I've lived there, my sense is that their system intrudes even more than ours into one's personal life. But I don't have a study to prove this. But it can get worse, you're right. But by the way, if you think what's worse, just remember where administrative law comes from, right? We didn't just invent it. The story is, pragmatic, democratic-minded progressives invented this in the 1890s and again in the 1930s. Nonsense. They learned it after the progressives studied it in Germany with the likes of Treitschke, and who invented the notion of a Maßstaat. And we know where that led to. So this comes out of the German civilian absolutist tradition, and we should celebrate the heritage of absolute power, of administrative power, to understand what it is. So there are even worse continental examples where this could lead.
I just want to conclude one of the this perverse on my part, but one of my favorite courses when I was in graduate school was on administrative law. I know it's character flaw, and one case, the area that always struck me as being the most striking was IRS, at least back in the late 70s, where the IRS had an administrative law principle that any case decided by an administrative court under the IRS actually was not a precedent for any other follow-on court. So even if you were to try to follow their case law, it actually wouldn't particularly help you.
Yes. May I just have 30 seconds? So I used to be a tax lawyer, and I remember being puzzled by this at the time. Yes, yes, and I'm actually going back to tax law last. And it puzzled me at the time, but I didn't put two and two together. And it's through this project that all these disparate bits of arcane knowledge come together, and you realize just how awful the system is. By the way, don't give up hope. I just want to add a little 2 cents at the end here, because some of us are thinking of starting a little civil rights organization to deal with this problem. This is a subject that is ripe for litigation of a different sort that's been conducted thus far, and that I think will be very effective. So I think we should look forward to real change.
Well, please join me in thanking Philip for this wonderful presentation.
Thank you.
And please join me for a drink.